Good evening, this is John Milburn for Laws 12062 Alternative Dispute Resolution. We're down to the business end, we're down to week 11. This week I want to talk about a number of different things, but there is a common theme, and the common theme relates to keeping your eyes open for some of the ADR processes that may not be as directly obvious as you might think. Peter, I'll just get you to mute your microphone if you would. Thank you. As always, I encourage people to ask questions as we go, either using the chat facility or simply unmute your microphone and proceed from there. Before I do, can I just apologise to those of you that have been diligently answering the questions for the weekly problems, and I have adopted a different style this term. I haven't actually gone through the problems week by week. I've provided some answers, but for those of you who have prepared in that way, I thank you very much and I appreciate it. All right, so for our second assessment, we don't know what the topic will be, but we've got some idea. It might be to do with trying to put forward different options to assist parties in resolving a dispute using ADR principles, or it might be something which calls upon you to give me your thoughts about how you would actually practice in ADR in a certain area, establishing a game plan, where you get your work, how you would source your work, what's the basis upon which you could call yourself something to do with ADR. So they're kind of the two main areas that you might want to concentrate on. Now, within the context of coming up with a game plan for people that are interested in an ADR solution, there probably are some general overarching things that you'd always want to consider. So I'm going to ask if people could give me some idea of what they think the general ADR tools or processes might be, irrespective of the type of dispute. Are there any thoughts?
John, are you referring to the way that you're going to approach each client and specific dispute individually? Like, for example, you know, if you've got husband and wife, you're obviously going to be quite conscious of history there, as opposed to a shopkeeper and, I don't know, someone who bought a packet of chips, so to speak. You obviously, is that where you're referring? Is that where you're trying to lead us?
That's a really good point. Knowing the parties and getting a feel for the relationship between that party and the other party in the dispute. Now, that's an excellent issue. And it's kind of along the lines of what I'm trying to lead you to, but I like that. That's a really good comment. So someone comes to you, doesn't matter what type of dispute it is, but you wish to canvass ADR options, or maybe they ask you to canvass ADR options. What are we going to talk about, or where do we need to look in order to provide some proper advice in a general sense? Jason says, look at the parties, the nature of the relationship, and that's good. What else?
How much time they have to make a decision.
Okay, yep. Give some thought to time. That's always a factor. And when we talk about time involved in litigation, what's the other thing that we almost talk about in the same breath?
Cost.
Cost, exactly. Very good. Thank you, Terry. So far we've identified that it doesn't matter what type of dispute, we've really got to talk about time, cost, the relationship between the parties. Molly says, you know, what type of dispute resolution suits the parties. So that's a good idea too. Tailoring the dispute to the parties is a good idea. So what are some other general things that we want to keep in mind when we're talking to clients about ADR options, no matter what the dispute?
John, should we always check to make sure that it's not, that ADR is an available solution, that it's not barred by statute or anything like that?
Oh, I like that answer. And that's something I really want to talk about tonight. And that is bearing in mind that you must consider some of the statutory issues that arise. Before we go into that in more depth, just think in general terms about negotiation and keep in mind that you need to provide advice to the clients as to the different types of negotiation. There's even more basic thing than that. And Terry, I will come back to what you're talking about because that's a really important part of tonight's tutorial. But bear in mind that we also want to keep in mind prevention. And prevention is something that's often overlooked, but I think it's important. So it's not a preaching session. We're not there to ensure that the client, that we preach to the client about what they should do in the future in a moralistic sense. But I think it's important that we keep in mind the ability to talk to the client about prevention. And prevention can be something that assists the particular dispute that they're in, or it can be something which is used down the track once they get through this dispute. Now, if you're talking about prevention within the context of this particular dispute as a way of assisting the parties in ADR, how is that possibly relevant? Hasn't the horse already bolted, so to speak? So why am I talking about prevention in the context of resolving a dispute that's current?
You don't want to be back there in 6 months' time doing the same thing again?
Yes, we don't want to repeat the issues. And what are the sorts of things that we don't want people to repeat? I'm being very vague, I know.
Their lack of communication that may have brought them to this stage in the first place?
Exactly. I think that's a really good point, Gordon. You need to talk to people about what has led them to be here, and communication's always a big one. And we use that then in the context of saying, all right, well, if that is a problem in the past, maybe if we address that now, it will help us to resolve this dispute, and it will help us to resolve other disputes down the track. So communication, improving that, is a good preventative advice. Is there anything else that we need to consider in the context of prevention? What else is an impediment to good communication? So we've discussed communication in the context of talking. What goes with communication? If you're not talking, what are you doing?
You're listening, active listening.
Exactly. And I love the word, thank you, Jason, active listening. And sometimes it's a case of training the clients subtly, or maybe not too subtly, about the importance of active listening as a means of preventing further problems, further escalations, but also as a way of resolving this dispute. So encourage them to listen actively, think about things from the other's perspective, and try to find out a way of identifying appropriate issues. So when you're speaking with the clients, you're almost in a mediation session, some of the same skills. You're talking about active listening. You're actively listening as well, and you're looking for things that they may have in common, something that you can agree upon or encourage your client to agree upon. Okay, so I won't take that any further, but that's just some general comments in relation to the issue of prevention and how we can use preventative tactics, or techniques rather, as a means of assisting in resolving the dispute that we have before us. Okay, so let's go back to Terry's point. Terry, you said that we need to consider whether there are any statutory prohibitions that apply that may be relevant in us discussing ADR options with a client. So can anyone give me any examples of where that may occur?
Criminal matters, perhaps?
Yes, that's a really good point, because in crime, you've got to be very careful that if you do embark in an ADR procedure, you do it properly. And if you do it not properly, you may find that not only is your client charged with a criminal offence, but you might be regarded as a party to that offence. When would you be when it would be very difficult for you to be involved in ADR processes in criminal law procedures?
I guess one thing you've got to consider is if there's a conflict of interest of some description.
Yes, conflict of interest. And how do we resolve, let's say, a stealing matter? How might we try to resolve that using ADR techniques on behalf of a client who is charged with stealing?
Can you try and negotiate with the prosecutor? Keep it out of court?
You can if you're very careful. Would you ever attempt to negotiate with the victim on behalf of the client as a means of trying to keep it out of court?
Doesn't sound advisable.
No, you've got to be really careful, because that may be that you're getting into the realm of trying to essentially bribe a solution. It's not the right term, but the compounding is a crime in itself. So you've got to be careful. The other thing that you've got to be careful about is, in reverse, using the criminal law as an ADR process, and specifically be very careful against threatening to invoke the criminal justice system as a means of trying to resolve a dispute, because then you might be found to have committed a criminal offence yourself. So thank you for that discussion. All right, so the point is that sometimes it may be that ADR is not the right process, and you've got to be very careful. We will talk more about crime. In fact, I'll deal with it now. In relation to crime, there are a couple of things that I like to keep up my sleeve when it comes to negotiating. The first is that we do negotiate in criminal law. In the magistrate's jurisdiction, we use a thing called case conferencing processes. Case conferencing came in officially in 2010 as a result of the Moynihan reforms. We used to do it beforehand, but now it's actually legislated as part of the procedures that we can case conference. It's without prejudice, and my personal view is that that should be between the lawyer and the prosecution section, not the client and the prosecution section, not the client and the arresting officer or the investigating officer, and not the lawyer and the investigating officer. So keep it at arm's length between the two parties that have the task of advocacy and court work. So that's case conferencing. Within that, we have some things that we can use from time to time. One of those is for stalking charges. We try to resolve this using alternative means, and those alternative means usually require us to consider a restraining order as an alternative. Now, if I might be able to find one of these restraining orders and put it on the screen, but you can see it there. It's a restraining order under section 359F of the Criminal Code. And as luck would have it, I don't think I'm able to find this quickly enough to put it on the screen, but that's an option that's available to you. Okay. In relation to children, we have a specialist regime as well, and that is in relation to case conferencing, juvenile justice conferencing. For a while we didn't have it, but it's been reintroduced through the Commonwealth, through the present government. So case conferencing, juvenile justice referral rather, is a way of trying to deal with a criminal charge involving children without it going to prosecution. Now, in relation to drugs, we have a separate one as well, and it's the court diversion program. That's the form that we use for court diversion in relation to drugs, and it's available for people that are in certain circumstances, only first or second time for referral, and no convictions that relate to particular charges of violence. So it's a form of ADR, and it's an ADR in two senses. One is that it can be used at the police level, so that if someone is charged with a drug-related offence or investigated, the police can refer those people directly to drug diversion, Keep that in mind, because it's an ADR process in crime that will assist your clients in that they don't even have to go to court. Or alternatively, if they are charged and they do go to court, it's something that you can complete as an application before you walk into court, so that by the time it is before the magistrate, you have already applied for the drug diversion, and it gives the magistrate an option to impose a good behaviour bond with an obligation to attend drug diversion as an alternative to the imposition of some other fine. So not directly ADR at that stage, but something close to it. So you've got to know those sort of specialist areas. Now let's talk for a moment about specialisation in ADR procedures. So coming back to Terry's point, sometimes you're prohibited from going to ADR in certain areas. So what's the contrast? What's the flip side of that?
Whether you have to do ADR by court mandated.
That's it, Peter. Yep. So how embarrassing if you take on a case, provide a costs agreement, outline the procedure, map out the plan, and even suggest an ADR option as part of that plan, only to find that once you embark on the process, statute directs you to go a different way. Suddenly your client is wondering whether you've really thought this through, whether you're experienced in it or not, and of course all your cost estimates, time periods, guidelines all might be out the window. So how do we find out whether some particular ADR process is mandated, and if it is mandated, where and in what documentation will it be mandated?
The relevant legislation.
Always good to start with the legislation. So if the take-home examination paper requires you to consider a dispute that involves, say, a family law issue, where do you think you might look at the start before you even give specific advice about ADR options?
The Family Law Act.
Yep, absolutely. If you've got a civil dispute in the Queensland jurisdiction, where do you think you might look to get some guidance about ADR?
Civil Procedures Act.
I'd always have a look at that. But it's not just the legislation, is it? Whether we're talking state or federal, what other sources of our law, which is not case law, might be relevant when it comes to considering ADR procedures?
Civil procedure rules.
Okay, so in a state context, and what do we call the civil procedure rules? There's one more word at the start.
Uniform.
That's it. Yep, uniform or UCPR. And if you haven't seen the UCPR, it's a huge document. It goes for 700 odd pages, and there are, I don't know, 900 rules, I think. It's fascinating reading, but it's actually quite sensible, and it really works quite well. So can anyone tell me what part of UCPR, if at all, would be relevant to ADR options and mechanisms? If you've done civil procedure, you'll be at an advantage here.
I've done it, but I can't remember the actual part. But the court can direct parties to ADR of its own volition, isn't it? All parties can also ask, in certain circumstances, to have the matter referred to ADR.
Exactly. Thanks, Terry. So have a look at part 4 of chapter 9, which deals with early disposition. I've just got my notes here, and Rule 319 says the registrar may give notice of a proposed referral to ADR. The court may direct the registrar to give written notice to the parties that the parties' dispute is to be referred by order to ADR process to be conducted by a specific mediator or case appraiser. Now, it then goes on to talk about proceedings referred to ADR are stayed. That's Rule 321. 322 says A party may not impede an ADR process. Rule 323 says this is a referral of a dispute to an appointed mediator. Rule 324 says mediation must be within 28 days after appointment, and then goes on to talk about the agreement. In Rule 329, the mediator must ensure that an agreement mentioned in the Civil Proceedings Act 2011, which I think Gordon mentioned before, Section 48 is placed in a sealed container marked not to be opened without order of the court and filed in court. And then it talks about Rule 331, makes reference to Section 49 of the Civil Proceedings Act 2011, requires a mediator to file a certificate about the mediation. Okay, let's just stop there. So I would urge you to look at Rules 319 through to 333 inclusive, particularly 331. So I didn't make a note about 332 or 333. So that's going to be really important if you're involved in a dispute where the UCPR applies. Would you agree? So we need to know that stuff. It also begs a few other questions, which to my mind brings in the second possible scenario for the take-home exam. And the second possible scenario for the take-home exam is, all right, if you wanted to be this person who's involved in ADR process, what's your authority? How would you get your work? What would you do? So when I read Rules 319 through to 331, I see this reference on a number of occasions to the ADR process to be conducted by a specified mediator or case appraiser. I'll get to case appraiser. So you might think, oh, I wouldn't mind being a specified mediator. So how do I become a specified mediator so that I can receive referral work pursuant to Rule 319 of the UCPR? And then that specified mediator is referred to throughout that division, or that part rather, in the sense that the mediator has certain obligations to do certain things within a certain period of time. So you might think, well, how would I become that type of person? Now, Rule 319 also talks about a referral to a specified case appraiser. So what's a case appraiser and why is that different to a mediator?
A case appraiser actually can make a decision, can't they, on basis of the mediation, whereas the mediator is just mediating between the parties. The case appraiser can actually make a decision or a determination.
Yeah, so a case appraiser is more like an arbitrator. And if we look at Rule 334, thank you for that, Terry. 334 says that there's referral of a dispute to an appointed case appraiser. So there we go again. How would you be an appointed case appraiser if you thought that would be a good job? A referring order for a case appraiser must appoint a specific case appraiser. All right, so it's like an individual. So I've had the benefit of that. I've been named as the party that is the mediator or whatever it might be, and include enough information about pleading, statement of claim, etc. The case appraiser, now Rule 335 says the case appraiser has the power of a court referring the dispute to decide the issues in the dispute, and a party who's dissatisfied may elect to go to trial. Okay, so we've now got to think about whether the UCPR applies, and we have to think about whether Part 4 of Chapter 9 applies, and we have to think about whether the matter is likely to be referred to mediation or case appraisal, and we have to think about whether we wish to weigh into the argument about who is the specified mediator or case appraiser. So a whole lot of things that we need to think about. And you need to identify those sorts of issues as part of your flowchart when you're speaking to the client about the likely time, cost, risk associated with litigation. So any questions about that part of UCPR?
could I assume that if you're just starting out, you would probably not go for being a case appraiser? You'd want some sort of you'd want some sort of experience as a junior in that before you went in as a case appraiser. Is that true?
Yeah, I think that's a fair comment. And I think statistically mediation would be far more common than case appraisal. At least that's my experience. But no, that's a good point. And Jane, it is part 4 of chapter 9, as I recall, of the UCPR. Rules 319 through to, go right through to 343, maybe a little further. Okay, so the point of that exercise is to say, when you're structuring an ADR plan for a client and providing them with options, you must consider the statute and you must consider the rules in the state jurisdiction. That would be the UCPR 1999. Do we need to consider anything else which is part of our law, which is not our case law? So we need to consider statute, we need to consider the rules. What else might we have to consider in the context of organising an ADR process?
Whether there's any contract agreement between the parties that we need to look at the terms of?
Yeah, that's important. It's not the answer I'm looking for, though. So I'm being too vague. I'll try to make it a bit clearer. And so thanks, Terry, for that. So when we talk about our law, we talk about essentially statute and case law. So the statute law, the common law. So forget about the common law for a minute. Just think about the law that is created by Parliament, and then think about the law that's created through the executive. So statute, of course, is at the top of the rung. And then we have rules. What else do we have which is, if you like, part of the structure of litigation?
Regulation?
Yep, regulations. Thanks, Jason. So there may be some relevant, yep.
Court processes or procedures?
Yes. And what do we call that? And that's it. What do we call those court processes or procedures? I mean, and where do they come from?
Is that the Supreme Court rules?
Yeah, we don't have Supreme Court rules as such. That's all now part of the UCPR, which is common to
practice directions?
That's what I'm after, practice directions. All right, so you must consider practice directions in the context of ADR as well, because it may be that there are specific practice directions that give you guidance and impose obligations in relation to ADR options for various types of disputes. So it gets a bit confusing. You're looking at all these different options. Now, I also take environmental law. So what I'm going to do is share the screen and just show you a couple of things in relation to environmental law, planning law type issues. Now, if you can bear with me while I go through this process, try not to lose you. Can you see the other screen now?
Yeah, I can see the screens there, John.
Okay, so there should be the two parts to those screens. And on the left-hand side, we've got a paper that I wrote last year for the CQU Property Law Conference in relation to ADR and some developments in environmental law. I highlighted, for the purposes of tonight, I'll just mention that I highlighted some new practice directions as they applied for the ADR mechanisms in relation to the Land Court. Practice direction number 1 deals with referred matters, and practice direction number 2 deals with ADR in the process of an appeal under the Land Valuation Act. I'm not sure if I've posted that paper to Moodle, but I'll do that. Now, In that paper, I've made reference to Practice Direction number 1 of 2015 for the Land Court and Practice Direction number 2 in the Land Court. So if we look on the right-hand side of the screen, and that's my son in the background diving into the water at Noosa, we see that here are the practice directions. So where do we find these practice directions? Anyone tell me where we find practice directions?
Just on the Queensland Court website.
Yeah, it's pretty simple. Just the Queensland Court's website should be in your favourites bar for internet. It's just it's a good website, and it's really easy. The other thing that you want to have a look at is the bench books. If you haven't already looked at bench books, they're terrific. You know what they are? They're the guides used by judges and magistrates, but mostly judges, in explaining certain aspects of law. So it's a great resource to look at. And also it gives you a really good idea to tell your clients what you can expect the judge to say in certain scenarios. All right, so here we have the practice directions. We have the practice directions for the Land Court, but bear in mind, of course, we have practice directions for the other courts as well. Down here is the Planning and Environment Court, so we have some practice directions there. Mental Health Court, Magistrates Court, Supreme Court. So we have different practice directions that might apply in different circumstances. So, but for the moment, we're looking at the Land Court, just as an example. Practice directions, and you'll see here we have the Land Appeal Court. Well, I'm not after that, I'm after the Land Court. And practice direction number 1 is the one that I'm just highlighting as an example. I'm not saying this is it might be on the take-home paper, I'm not saying it is, but I'm just highlighting it as an example. And of course, I can't find it now. I think I mentioned to you, I've got a new laptop and I've linked it to a screen, and I'm having all sorts of kittens trying to make it work the way I want to. But what I will say is in that practice direction, and if anyone can see where this thing is, I'll try it again. It highlights a number of things which are relevant to, no, I'm sorry, I'm not going to work, that's not going to work for me. So I'll stop the share. You know where to look for that practice direction, and I'll just refer to some of my notes in relation to it. Okay, so the practice direction is one where the president of the court made an order, or made a practice direction to the effect that in relation to certain matters that are referred to it, which are called referred matters, there is a certain procedure as to how the court will undertake its work in referring to those procedures. So the practice direction says, in fact, I know how I can do this. I've already got it there, sorry. I'll go back to sharing the screen. My apologies. We'll get there soon. Okay, so there's the practice direction number 1 of 2015 in the Land Court, and it says there are certain procedures that apply when considering alternate dispute resolution, and you'll see that there, preliminary conferences and mediation in certain matters that are relating to, and I'm looking at paragraph 5, referred matters where a member or judicial registrar may arrange for the parties to attend a preliminary conference or mediation, and then goes on to say it's without prejudice, etc. Parties must make a genuine attempt at the preliminary meeting. So the important thing for tonight's purpose is to highlight that we need to consider statutes, we need to consider rules, we need to consider regulations, we need to consider practice directions, and we need to be mindful that any one of those things may have a bearing on the way in which the ADR process is to be conducted. So this is a practice direction that refers to matters that are referred to the Land Court that come from disputes in certain parts of Environment Protection Act or other pieces of environmental law based legislation. Okay, so that's the first practice direction. The second practice direction is one where the courts have to consider preliminary conferences for appeals. So I don't have that one up on the screen. Also, for example, we have the Planning and Environment Court. So if we go back here, we see the Planning and Environment Court also has its own practice directions, as do many of the other courts. And you can see them there, practice directions that apply to the P&E Court. P&E Court is part of the District Court, essentially. And you'll see the P&E Court practice directions. Again, we have them for 2015, 2014, etc. The one that I want to highlight for the moment is practice direction number 2 of 2014, which is here. And it says that when it comes to a dispute that involves a planning and environment court matter, there are certain very particular processes that must be adopted. The parties must prepare a dispute resolution plan. There's a pre-call over review. There are directions orders that apply. Now, have a look at this. An application for order or direction about the future conduct of proceedings must be brought as soon as possible, but in any event, within 6 weeks after you institute the proceedings. So that's really fast, but it's necessary because what it does is immediately set out the plan of attack in relation to a planning and environment court matter. It includes draft directions orders, and it talks about experts at conclaves. Now, that's all important as far as getting your evidence is concerned, but it's really important from an ADR perspective as well, because you need to think about what experts and what evidence you need to gather before this matter is referred to an ADR registrar at an early stage. And if you have a look at that practice direction, you'll see that the time periods are really quite quick. So again, the purpose of that was not to specifically talk about environmental law, but to say, look, that's an example of a particular area where you need to consider the practice directions. They may well be important and relevant. Okay, are there any questions there? Now, what you might be thinking is, well, how do I know where to look? And that's always a tough one, because in some of these practice directions or rules, for example, in the Planning and Environment Court, the rules may well specify that they apply, but if they don't apply, if they're not relevant or they're not covered in those rules, then the UCPR applies. So UCPR would be a default situation. And really it's a matter of just making sure that when you structure your ADR plan and provide client with costs and estimates and timeframes, you look at it broadly and think about the statutory obligations that might be imposed upon you or your client as part of that. Speaking of the statutory obligations, bear in mind the general statements that are made. For example, in the UCPR, I think from memory it's Rule 5, which is sort of pretty common type rule, talks about the philosophy, the overriding obligations of the parties. And one of those is to facilitate the just and expeditious resolution of the real issues in civil proceedings at a minimum of expense. So that's the sort of thing that you might rely upon when you're arguing for an ADR option, irrespective of what the dispute might be. Okay, no questions so far? All right, I'll leave you to read your text in terms of the future of ADR. I'm just looking at my notes for, we've talked about case conferencing generally. In criminal law, we've talked about children. We've talked about drug matters. I've talked about stalking. Justice mediations, talked about it briefly. Peace and good behaviour, talked about the land court. I think we're getting close to the things I wanted to talk about tonight. There is one other thing in QCAT, which is another area close to my heart. We have some specialised areas of ADR practice. I think I've mentioned to you the hybrid hearings. So you may get a question about that. Hybrid hearings really relate to tree disputes, dog destruction notices, things of that nature. And the procedure is pretty simple. Parties attend a hearing, present their case, argue the case. The member will write a decision, seal that decision in a sealed envelope, and then embark on a facilitative form of mediation, giving the parties one last chance of resolving the dispute before the order is made if they can't resolve that dispute themselves. Okay, so are there any questions or are all good?
What was the exam on again, John?
The exam, what was that, sorry?
What was the topic of the exam again? You were just going to refresh it in one sentence, I thought you said at the start.
Oh, okay. So the take-home exam is, I won't let you know the topic right now, but there are two main areas that you need to consider. The first is trying to structure an appropriate ADR option for your client. When you're doing that, think about what's involved in prevention, what's involved in, I suppose, general ADR options like negotiation, and think about an appropriate structure for the ADR process. Now, if you talk in general terms for that question, if that is the question, you'll pass, but if you want to do well, you'll certainly need to make it very real. And when I talk about real, I mean I would ideally talk to real practitioners and get a real feeling for the cost, the time frame, etc. But as part of structuring your answer, as we talked about tonight, you need to think about the statutory provisions, rules, practice directions, etc. as well. So that's part of the likely take-home paper. The other part is you practicing in some of these areas. So it might be the case of thinking, well, I'd really like to be a dispute resolution board, practitioner, dispute resolution practitioner in a certain area, in building disputes or whatever it might be, or family law, and think about how you would be, say tonight we've talked about being a case appraiser, receiving referral work from the district court. How would you actually go about doing that, etc. So they're the two parts to the paper. Sorry, it's all very general, Jason.
John, you disappoint me a little bit. I hold you in very high esteem, and I really did think you were going to narrow it right down for us.
Yeah, and look, if the take-home paper was 24 hours or 48 hours, I'd be so much more specific. But given that I've allowed a very generous 4 days, plenty of time. Thanks, Jason.
Thank you, John.
When you're talking about those two different options that it may be, do you mean it will be one or the other, or is the paper potentially covering both of those questions?
It could cover both. The paper last year, from memory, only covered one. So this year it could just be a problem-solving issue. It might just be an issue to do with how to set up in practice, or it might be both. I'm being horrible tonight, Melissa. I'm sorry.
You are. You're not helping us.
So what I want you to do at this stage is just read very widely and just try and give some idea to where you might start to look once we narrow it down and we release the paper. The idea is to really think about how we use ADR in practice. So if I make it narrow at this stage, you may not look as much as you would otherwise. But thank you.
John, will we be having a tutorial next Thursday night?
Yeah, I've got a problem next week. I start my bar practice course next week, so I don't think I'll be available. The Zoom session is available. You can go online, and I think like the first week we had, where there was lots of chats between you. Feel free to do that, and you are allowed to collaborate in general terms, but just be careful not to be too specific. So you can discuss the paper in a general sense. I'm happy with that. So that could be something that you do on next Thursday. If I happen to be free, it's unlikely I'll join you, but the answer is probably not as such. All right, any other questions? Thank you for your participation this term.
Just one
Yes,
more.
Jason?
Will you be available for some feedback after our assessment results are released, after our final take-home paper? Will you be providing that, or can we contact you for some individual sort of comments?
Sure. I think the university policy generally is no feedback for take-home papers. From memory last year, I did provide some degree of feedback, and I'm always very happy to provide feedback to students, and you can ask me through UCRU, or if you prefer, you can send an email. If you do send an email, and I think it's a good one for UCRU, even though the term's finished, I'll still get you to ask on UCRU if you don't mind. But no, I'd like to give you some feedback. One of the problems is that with the take-home papers, they're with me, and invigilated exams are the same. I don't have them for very long, so that might be. Although, actually, I think I do want you to upload through Moodle, so I may be able to access those afterwards as well. All right. No other questions? Gordon, preparation. That's good. I like that. All right. Well, thank you again for your participation this term. I'll sign off. I'm still available through UCRU and email, maybe next week, but I doubt it. And we'll release that paper, and all the best. I hope you go well. I'm sure you will. So I'll end the.
Thanks, John.
I'll stop the recording now. All the best. Bye.